Well, hello, everyone. I'm Scott Carpenter from the Carpenter Law Firm, and my face is supposed to be on the screen. I'm not sure where it is, but I am here. And today we continue our series of discussions about legal issues for churches here in Arizona. And I may multitask here and try to figure out where my face is on the screen. I don't know why it disappeared. And I'm not sure that I'm tremendously camera ready today, although I thought I was. I thought I had put plenty of gel in my hair, but I don't see it on the screen, and you're not missing anything. But we'll talk about real estate and property issues in church in 2024. And I've got a few things that I want to present today as part of our ongoing discussion of legal issues in church for 2024. And I've got it in four categories. The first is acquisition. And, how are we acquiring real property for churches in 2024? How is it different than it used to be, perhaps? And what are we acquiring? Is it a lease? Are we going to gather as a church body on property the church owns? And I'm talking about a congregation. Or are we going to purchase property? How do we do that? And the second one we'll talk about is financing. And then we'll talk about compliance issues that come up from time to time. And then something that I refer to as REO. This is not REO Speedwagon for those of you in Gen X or whatever generation fell in love with REO Speedwagon, and perhaps I'm guilty of that. This is real estate owned, and it's a term that's often used with respect to banks that end up owning real property. And this happened a lot in the Great Recession, but we'll cover that when we get to it. REO, real estate owned. Let's talk about acquisition. So we see a good bit with startup churches that either come out of larger churches that do what we'll refer to as a church plant. Where are we going to meet? Are we going to meet in someone's house? Are we going to meet in a school? Are we going to meet in a commercial center, strip center, sometimes it's called? This often involves a lease, leasing an initial meeting location. When we at the law firm here review a lease, we are really concerned about four lease terms that come up over time that trip up the entity that's doing the lease. We'll call it the tenant. And in a commercial lease, the tenant can get tripped up on four terms that we zero in on when we're reviewing a commercial lease for a commercial tenant. The first one is, what is the initial term? Are we leasing for a year? Is it 10 months? Is it 24 months? Is it 36 months? We've got to know that when we enter into the initial lease term. And sometimes people enter into these leases and they're not really focused on what is the initial lease term. And they think, well, we talked about a 1-year lease. But if we're not focusing on the exact language of the lease that we're signing, then the verbal discussions become merged into the written lease, and we can have a misunderstanding. This happens a good bit because a written agreement, some of the boilerplate, and people refer to lawyers and say, well, that's legalese, boilerplate, the small print in a written document. Some of that legalese, as it's sometimes called, or the boilerplate of an agreement, that language sometimes, in fact, it almost always says, this written agreement merges all discussions that have occurred between the parties. No verbal conversations that have occurred between the parties have any weight legally between the parties. All those verbal conversations that occurred before the written agreement are merged into the written agreement. nothing we've discussed between us has any weight at all. And the only thing that matters is the written agreement. So whatever you've discussed, tenant and landlord, or broker, tenant broker, landlord broker, whatever's been discussed between anybody doesn't matter. The only thing that matters is the written agreement. So if it says 36 months in the document you've signed or digitally signed on DocuSign or hand scribbled, that's what matters. So when we review these for our tenant clients, church tenant clients in a startup, what is the initial term? And then the second thing we're concerned about is how does it renew? Does it renew at the end of the initial term automatically? At the end of the initial term? How do we cancel at the end of the initial term? How do we stop the automatic renewal of that first term? Let's say the initial term is 1 year. Does it automatically renew for an additional 1 year? Or if it's 3-year initial term, does it automatically renew for an additional 3 years? And how do we cancel? Does it say you can cancel that automatic renewal if you cancel within 90 days of the end of the first 3-year term? And what ends up happening often when we have these automatic renewals, somebody has to calendar that window within which the lease has to be canceled. You have to have that 90-day window calendared, and somebody has to remember that 9 months into the initial term is your cancellation window. But this often doesn't happen in the real world. The church, the tenant, enters into the lease agreement. Everything's going along fine, but a year into it, somebody says, well, we've got this property that we're looking at buying, or we might be able to lease another piece of property because we're growing and we have the opportunity to move into a bigger space. And the idea is, well, let's get out of this startup lease space. And you figure, well, we can leave here anytime. No, you can't, because the initial term automatically renewed into a renewal term, but you could only cancel out of it within that 90-day window before it automatically renewed into an additional term equal to the initial term, but it needed to be calendared. And as a lawyer, our job is to review that at the beginning, but we generally take the view as a law firm that our client is doing the calendaring. And it's simply one of those deal points that we point out at the beginning. There's an initial term, and if it's automatically renewed each time that an initial term rolls over. So the 4 issues that we're looking at is what's the initial term? How does it renew? And then the third one is how do you get out of it? Which is different than what's the initial term? How does it renew? But if we want to terminate the relationship, how does that occur? Which is a slightly different concept than how does an initial term renew and what are the renewal terms? If we wake up one day and say, we want to terminate this relationship entirely for cause, the landlord has not provided a habitable space. The air conditioners don't work, the roof is leaking, that kind of thing. How do we terminate the entire relationship? That's an important question at the beginning. And so we have to know at the beginning, how would we terminate this relationship at the front end? And then the fourth question that we look at as lawyers is, if there's a lawsuit, and somebody needs to, if there's an incident on a Sunday morning, and a visitor is on campus for a Sunday morning service, and they're in the bathroom. And this is a leased space from the landlord, and they slip and fall in the bathroom. There's water everywhere. The sink is exploded, and there's water everywhere, and they slip and fall, and they file a lawsuit against the landlord. They can tell from the property records that it's owned by the landlord. They sue the landlord and they sue the church because they know they went to, Calvary, whatever church. They sue everybody. Well, who's defending whom in that lawsuit? That's a question of indemnity. And that should be spelled out in the lease. And then finally, we look at the insurance provisions, because this question of indemnity, who's defending whom in that lawsuit, comes up so routinely. Most of these lease agreements require both parties to provide insurance that would cover that lawsuit scenario that I just outlined. There's a slip and fall in the bathroom. The landlord is going to want the tenant to have certain types of insurance, and the tenant is going to want the landlord to have certain types of insurance that name the tenant, and the tenant's going to want insurance that names the landlord as an additional insured. So, as you can see, in a simple lease of an empty shopping center space, a former retail location of a grocery store or some other big box retailer, you might say, well, geez, never really thought about all of that. And some churches would say, well, we love the space. We can see a stage over there, put some lights here, put a bunch of chairs in this open space location. And the landlord put a lease in front of us, and we signed it. The rent amount was fair, and it made a lot of sense to us. Never really occurred to us to negotiate the terms of that lease. And over the years, we've had plenty of church clients that have ended up with what you could call stress and trouble because of these lease provisions that ended up with challenges in all 5 of these basic areas. And I'm not trying to create stress or problems, but these things can become an issue for churches when they're leasing space from landlords, and not just in startups, but because interest rates and land values are so high, both the land values, the land acquisition cost, and the interest rates are so high, more and more churches are leasing space. And this is not just a startup issue anymore, although for many years, leasing space was a initial phase of a church congregation issue, but it's becoming more of a, I wanted to say a permanent status of a church, but it's more, churches are lasting longer in leased space perhaps than they used to, or at least some people believe so. All right, let's talk then about the next phase, which is land acquisition and construction. First question is, where are we finding this land? Land has become more expensive than ever. I've practiced law here in Maricopa County for 30 years, and the joke that we've used for years is drive till you qualify. And the theory being, the further you go from city center, the cheaper the land would be. You're a young family, you start downtown Phoenix and drive until you qualify for the mortgage. It's a bit of a joke because now everything's expensive. And, it's not so much true anymore. Everything's expensive. But drive until you qualify was a home builder's joke. It's not really funny, but that's what one could say. And even some churches would say, well, we'll acquire land and we'll, just keep kind of moving further out. Well, interest rates are higher than they've been in a long time. I don't want to say higher than ever because many people remember the early 80s. I wasn't that old at the time, but I do remember billboards that offered 5 and 6% on savings accounts, and that was a function of mortgage rates that were 15 and 16%. People would love for their savings accounts today to offer 5 and 6%. Certainly not the case, but that was something strange at the time. But the financing options are difficult to acquire raw land. Banks have not wanted to finance raw land in a long time. So for churches to acquire raw land and finance it, the options are limited from a traditional lender standpoint. When I say traditional lender, I'm talking about Chase, Bank of America, Wells Fargo. And that really stems from problems arising out of the Great Recession, where those lenders did not want to end up foreclosing on raw land for reasons that are really not worth going into today. There are denominational lenders affiliated with particular church denominations, and you might be familiar with some of those. And their lending practices, they can do whatever they want to with their own lending underwriting guidelines. And then there is an old, less used today concept of church bonds. A church bond is actually a relatively simple concept where, as a churchgoer, I would say to the church, I will loan you $50,000, and church, you give me a promissory note, and we'll call it a bond, and church, you'll repay me at an agreed upon interest rate. I'm making an investment in a promissory note where the church agrees to pay me back at an agreed upon interest rate. Let's call it, for the sake of this discussion, and I'm not saying anything about anything specific, but for the purposes of today's discussion, let's call it 7.5%. That's the coupon rate for this discussion. It's hypothetical. And so I'm loaning the church my money, $50,000 at 7.5%. It's called a bond, but it's really a promissory note. The church has borrowed $50,000 from me at 7.5%. Now there's an intermediary. There's a company that is receiving the money from me, the 50,000, and giving it to the church. And the church is going to repay the money to the intermediary. We'll call that the trustee. And that company is going to take a piece of that as their fee for being the intermediary. In America, we're great at that. You could call it a title company, you could call it a trustee, you could call it the intermediary. It doesn't matter what you call it, but they're going to take a fee for their service of being the intermediary in this church bond transaction. So the church is going to sell bonds at the coupon rate, call it 7.5 for purposes of this hypothetical. And essentially, the church is going to borrow the money from its own churchgoers and raise the money that way. Now, most churches would probably just do a capital campaign and ask people to donate the money. But every once in a while, a church will say, well, let's, instead of borrowing the money from Chase or Bank of America or the denominational lender, only to go to the congregation and ask them to donate through additional tithes and offerings to pay back the lender. Let's ask our members to be the lender, and we'll offer them 7.5%. And then maybe the churchgoers who've borrowed from us will tear up the promissory notes eventually and forgive the debt. And maybe they will, maybe they won't. And that would be their form of a tithe or offering to tear up the debt. So that does happen every once in a while, and it still does happen. And then we have construction loans, but at current interest rates, this is challenging for some churches who then see this as a challenging thing to ask their membership to do in terms of a capital campaign. You multiply out the cost of construction, which is higher now than it's been in years, and then on top of the land acquisition cost, and then we have to do a capital campaign, which is now higher than it would have been in past years. So it's a triple whammy. Land acquisition costs are higher, construction costs are higher, and then the financing costs are higher. Land acquisition, construction, interest rates, triple whammy. Now, the other thing that can happen is there's always a private investor out there who will say, well, if the prevailing interest rate is 7.5% and you're having trouble with a traditional lender or a denominational lender, and if you don't want to go to your church membership and sell a bond or a promissory note, and the construction loan is difficult, I will loan you the money and I'm going to make up an interest rate here just for purposes of the hypothetical. I have money. This is not me, Scott Carpenter, saying this, but it's the hypothetical investor. I have money. I will loan it to you at 16% interest or 20% interest. There's a loan shark for any transaction, and that could happen. And the reason that it's a safe investment is because that private investor would want to take a deed of trust or a mortgage on the property. And if it's not repaid, the investor would foreclose on the property in this land acquisition and construction scenario. And because the property is so expensive in the first place, the investor would foreclose and repurpose the property. It might not be a church anymore. It might be a restaurant. It might be an office building. It could be the next Starbucks or whatever. So there's an investor who will lend money at the right interest rate for just about anything. So there's always a way to get it done. All right, let's go to the third piece here, which is compliance. Churches, of course, once constructed, must comply with ordinances and other governmental regulations. I have a church client this week that was cited for failing to adhere to a minimum landscape maintenance standard. And this crossed my desk because I'm the statutory agent for the church. I ended up getting the letter, forwarded it to my client. No hourly billing, of course. The city has the right to cite the church for violation of the landscaping minimum standard under the city ordinance. And the church has an obligation to adhere to the minimum ordinance standards. Is this a violation of the First Amendment, freedom of the free exercise of religion for the church to fail to comply with the city's maintenance obligations? Of course not. I mean, the church has to adhere to the minimum landscape maintenance standards, just like the office building down the street, just like the homeowners next to the church. And so we didn't even consider, when I talked to my client, we didn't even consider doing anything other than sending a crew out there to comply with the city's minimum maintenance standard. But I will say this is an opportunity to bring up this notion that since the year 2000, there has been a federal statute called the Religious Land Use and Institutionalized Persons Act, called the RLUIPA. And it was enacted in the year 2000 to protect the religious institutions from overreach by governments and local municipalities and cities who might discriminate against churches and religious institutions actually in land use decisions. Give you that are unduly burdensome or discriminatory in their land use regulations. Here's an example. This is from the Department of Justice's website. This is the example they give. A church is denied a permit to build an addition to the church to accommodate more Sunday school classes that the church believes it needs to carry out its religious mission. This may violate the statute if the town cannot show a compelling reason for the denial. Now, what would that compelling reason be to deny additional Sundays additional capacity to their building for additional Sunday school classes? It might be quite difficult for the city to do that. Then that's why they use it as an example. As it turns out, the litigation that's occurred since the year 2000 under this statute, one of the cases that has come up, there was a Muslim group that wanted to build a cemetery in New York. And as this group was mobilizing to do it, the town changed its municipal code intentionally to prohibit exactly what this group wanted to do. And the group filed a lawsuit under this statute and won. And quite quickly, the city rescinded its changes and they were able to build the cemetery that they wanted because the city intentionally changed its code to prohibit the Muslim cemetery that everyone knew they wanted. So what has happened over the last 23, 24 years under this statute is that the groups that have used it are not the Christian church groups, which is more kind of what it was intended to protect under the Clinton administration, but the post 9/11 discriminatory behavior that's occurred toward Muslim groups after 9/11. And there have been a number of cases where governments have undertaken activities to say it clearly, that to discriminate against Muslim groups. And they have argued under this statute that the government's behavior toward Muslim groups violates this statute. And so although we talk about this statute as protecting churches and Christian groups, it doesn't actually come up very often because governments tend to not do things that really violate the rights of regular, it's not the right way to say it, but churches the way we think of them, or that come up in the regular course of churches, the way that that we deal with them in our law practice here at the Carpenter Law Firm. But it's an interesting aspect of compliance as we move through this. Let's talk about REO. And again, REO Speedwagon, great band, but real estate owned. So as my law partner, Nick Eicher, and I deal with a good bit of the church legal issues that come into the firm, real estate owned is one of them that has come up the most recently. So I kind of want to pause here and tell you a few stories as we move through here. So churches sometimes end up owning real estate off campus. This is not where the sanctuary is, where the main offices are. This is real estate offsite. let's talk about how this happens. Well, one of the ways that this happens is a member leaves their home or a home in his or her will, and let's just make up a bequest. How does this happen? I'm leaving my home in my will to the church for use to house missionaries home on furlough. And this is easy to imagine how this happens. This person, and we're just going to make up a hypothetical person here, was a supporter of missions for years. This was the main advocate for the Sunday night presentations when missionaries would come back, and the click 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 of the circular pictures that go up and down in the fellowship hall, and they would come back from wherever they were deployed. I don't know if that's the right word, but they'd come back from Indonesia or wherever it was and do their presentations. And this member of the church was the number one supporter of sending Americans to faraway places on mission trips to be the church's emissaries abroad for that model of missions. So it's not a surprise that when the will was drafted in 1988, that this was the vision, that the church should have a mission house so that when those missionaries come back to Anytown, Arizona, that the church should have a home that the church owns so that those missionaries can stay there while home on furlough. So the church ends up owning the home. The person ends up dying because, as my pastor says, the mortality rate is still hovering right at 100%. So the member dies, and the will says, "My home, when I die, will go to the church for use to house missionaries home on furlough." So the church ends up owning this house. It's free and clear because this churchgoer was dedicated to no debt. And so we end up, the church owns the house free and clear. And that's how it happens. So we own the house, the church owns the house off campus. So we'll deal with that one first. Or there's another possibility of REO. Let's deal with this one. It could be that the church owns a parcel for future development, not yet ready for construction due to interest rates. So we've got a couple of different scenarios. Or it could be Nick Eicher, my law partner, it could be a parsonage that the church owns housing a pastor. So these are the REO scenarios I've outlined here today. You've got this parsonage that houses the pastor. So here are the challenges that we've identified. We still have all the compliance issues we mentioned earlier. When the city decides that there's a landscaping problem and it checks the ownership, it's all going to come back to Calvary Church, as I said earlier. We'll just make that one up. Under Arizona's property tax exemption statute, these properties cannot be used or held for profit in order to maintain your property tax exemption. We can't be speculating on the value. The parcel held for future development, we can't own that to flip it down the road. And we've got to be careful about that. And the member who leaves the home in his or her will to the church for use to house missionaries home on furlough, we're not in the business of property speculating. So a couple other thoughts here. The special challenge is we don't want to make any promises to the donor regarding the property conveyed to the church for the mission house. Because this is the thing that I've seen many times over the years when our church clients end up with this unintended property ownership situation. When our church clients end up with this property in a will or otherwise end up on the receiving end of a gift, often our church clients come to the conclusion that it might make more sense to take the property, put it into the open market, and deploy the cash back into ministry. Now, that may not be true for you. You might say, no, we need to own this real estate because we have people who come into town all the time and we have the resources to manage the asset. We've got lots of people in our church who are ready, willing, and able to manage the asset. They're skilled, and owning a house 5 miles from the church is ideal. And we have so many people who come into town all the time that it's perfect. It's so awesome and ideal to own this mission house. I'm just giving you the benefit of what I've seen over the years. And the other challenge is, if what I'm saying is true, that when you take a house and let's say it's worth $750,000, once you sell it and that $750,000 goes into the bank accounts of the church, it's gone pretty quickly. Ministries require cash. And as much as you would say, wow, $750,000 is a tremendous amount of money, we run a lean operation at the church that would go so far, that would last us many, many, many months. But it would only last so many months, and then it would I sneezed, and then it would be gone. And so, although it might be true that the church is not perfectly equipped to own and manage property, if you sell it and the money goes into the operations, it would only last for a finite period of time. So another thought is that, although it might be true that over the long term, the church is not in the REO business, that's true. So if you recall, in the Great Recession, 2008, 2009, 2010, banks ended up holding billions of dollars worth of REO after foreclosing on bad loans. Banks were the kings of REO. What did they do? They sold it all because REO was not their business. And it's sort of a thought that REO is not your core mission as an organization, same as the banks. The first thing they said was, we are not a real estate business. We got to remind ourselves, what is our business? We take deposits and we loan money. That's what we do. We take deposits and we loan money. The other thought I would give you is on a parsonage, because that was the third scenario I gave you back here. Let me go back one. Having a parsonage to house a pastor. I gave you 3 REO scenarios. A member leaves a house to the church to house missionaries on furlough, a future development parcel, or a parsonage. Here's why a parsonage is tricky. Nick and I have been dealing with a situation where a church owned a parsonage and they had a retiring pastor. And at a board meeting, someone said, well, the pastor is retiring. Let's give the pastor and his wife a tenancy for life in the parsonage. And that's all that appeared in the minutes. And frankly, they didn't even say it that articulately. A tenancy for life, for no rent. They can stay there as long as they're alive. Well, within a certain short period of time, the senior pastor passed away. So now his widow has been living there for many, many years. No written lease, just the minutes from 20 years ago. So what does that mean? Does the Arizona Landlord Tenant Act apply? What are the standards? How is it terminated? Does it only terminate when she passes away? What are we doing? Do we have to maintain it forever? What are the standards? It's a complete mess. We wouldn't be in the situation if the church didn't own the real estate. My point being, it's lovely to have a parsonage. It's lovely to give your senior pastor a parsonage. But my third bullet point here is providing a parsonage is not necessary, considering the housing allowance that's permitted under the Internal Revenue Code. My father-in-law was a pastor for over 50 years. He took the housing allowance. Most pastors we work with, most pastors I know, take the housing allowance permitted under the Internal Revenue Code. The church doesn't have to own real estate, doesn't have to own a house anymore. Plenty of churches owned parsonages going back 100 years or longer. But when the Internal Revenue Code was adapted to convert the concept of the parsonage over to a housing allowance, the pastor, go buy a house, take the housing allowance on your taxes. It was no longer necessary for the church to be in the real estate owned business. So if we go back a slide and say, maybe the member leaves a home in his or her will to the church to house the senior pastor, not necessary. We can still sell that house and take the money and put it into ministry, and the senior pastor can, or associate pastor or staff pastor can still use the housing allowance under the Internal Revenue Code. And it is not necessary for the church to take on the special risks and costs of REO. And we don't need to get into the ups and downs of the pros and cons and the costs and the risks of REO. As even from my quick example of, hey, we love senior pastor, founded the church, he's been here a long time, he's retiring, let's give him a tenancy for life in the parsonage. And then all of a sudden he passes away and the wife is there for 20 years. And all we have are some words in the minutes to try to figure out what to do 20 years later. And the house is falling apart. And it's a money pit, complete and utter money pit. So my next seminar is in September. You could sign up on the website, carpenter.law. I'm going to talk about testifying in court. The formal name is You've Been Called to Testify, Now What? Lots of circumstances in church work where you might end up having to testify in court. Sometimes it's in family court in a domestic relations matter. Sometimes it's an abuse situation. And there are a number of situations where we'll walk you through, here's how you could be subpoenaed. And there are a number of prep things that we can do. You might be deposed in a deposition, and we're going to walk you through what it looks like to testify, how to be prepared. And so we've done this seminar before. So if you ever end up having to testify in court, we want you to be prepared and ready for what it might look like. So if there are any questions, there's a chat feature. Love for you to type it in, and I'm happy to open it up and try to answer it. If not, happy to have walked you through this. I was camera ready today. I made a joke earlier, but you didn't see my face much today, but happy to have gone through this content with you today. And if there's anything we can do here at the Carpenter Law Firm to help your ministry or your church, we're always happy to help. I didn't change the date on my questions slide, I see. It is August 15th, 2024. I see a question. I just got a note that my face was on. All right. Thanks, everybody. Hopefully I'll see you next month in September and look forward to that. Have a great rest of your day.